Okay, so let's get started. I know it is 2 minutes past the hour. More people will be joining, and I really appreciate that all the attendees are joining despite the heat wave. So, welcome everyone. It is great to have you all here at the 4IP Council's webinar entitled The English Torpedo, Interim Global SEP Licenses, Territoriality and Defensive Anti-Interference in Europe. My name is Axel Frazzini. I'm the Managing Director for IP Council, and I will be your host today. As you might be aware, 4IP Council is a not-for-profit organization. We are based in Brussels, and we are dedicated to exploring the relationship between IP and innovation. Our aim is to identify the most relevant topics and to conduct empirical research through collaboration with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find a lot of information, free materials. The goal is really to educate all the parties to better understand what is intellectual property rights, what are intellectual property rights, and what this is about. So you have the summaries of relevant papers, guides, and studies. We also upload the recordings of all the webinars. So like this one today will be uploaded tomorrow. And we have a podcast called IP Stories, where we interview innovators, inventors, but also people from companies explaining their story. We also produce easy to digest content, such as the SMEs Corner, especially tailored for non-IP experts. Check. We have a new section that is called IoT and cellular standards made simple. It is a section that is very helpful because you can learn all about the benefits of standards and the Internet of Things across different sectors. It has been updated lately. We have also launched a new area, which is called the AI and intellectual property rights, with guides, videos, papers, and interviews to help you to understand how artificial intelligence is transforming the way we live, work, and create, but also addressing the pressing questions raised about IPR. But without further delay, it is really my pleasure to introduce our speakers for today's webinar, Dr. Niccolo Galli and Professor Giacomo Paili. So, Niccolo is a research fellow at the European University Institute Center for a Digital Society, a contract professor of IP and competition law at the University of Florence, and an attorney admitted to the Italian bar. Giacomo is professor at the Università di Palermo and partner at MPM Avvocati. He has focused his practice in international business law and international litigation. He has been admitted to the Italian and New York State Bar and is a member of the International Association of Procedural Law, the European Law Institute, as well as the Italian Society for the Research on Comparative Law, which is called SIRD. A final remark for the audience. Please do not hesitate to use the Q&A tool that you can see at the bottom of your screen. This is the way you can ask your question live during this webinar. After a short presentation made by the authors of the upcoming research paper, so the speakers to this webinar, you will be able to have all your questions answered. So do not wait for the last minute. Please do not hesitate to send your questions from the beginning. That said, Niccolo, the floor is yours.
Thank you very much, Axel, and thank you to 4IP Council for the opportunity to develop this research. And in this paper that is going to be shortly made available by 4IP, Giacomo and I take a look at the practice, the developing case law of UK courts regarding global interim license declarations and the European response. And with our respective expertise, we try to bring together intellectual property law and international private law to this analysis as a novel approach. And the roadmap for today, in about 20 minutes, we are trying to walk you through the analogy that we try to make. So as Italians, we are quite aware of the of Mario Franzosi's concept of Italian torpedo, and somehow we try to transpose it and apply it to certain cases of global interim license declarations by the UK courts. And so we developed this concept of an English torpedo. And we then delve into both a jurisdictional analysis and a legal basis analysis of the UK global interim license declarations, and then compare in what circumstances these declarations might become de facto equivalent to anti-suit injunctions, which is the most traditional instrument in private international law used already in SCP litigation. Then we move to the European anti-interim license injunctions, the new device that has been adopted in response to the UK declarations to defend the European jurisdiction, and some, let's say, the Euro condemned on some proposals to somehow break this cycle of possible torpedoes. So the background, and I'm sure that the audience of RIP is well aware, is the one of SCP licensing. And here, it's important to stress that we have quite important tension between the territoriality of patent law, recognized internationally by the several conventions, starting from the Paris Convention. And this implies that patents are granted and enforced at a national level. And on the other hand, we have global standard-based markets, and we all appreciate the globalization and the opportunity brought by interoperability and enhanced technology standards. That's let's say something that all consumers realize and benefit from. But nonetheless, there is this tension. So between the territoriality of the underlying intellectual property right that might read on the standard and the resulting markets that ensue from standardization. And in between, in this intersection, there are and sit the FRAND or similar licensing commitments before standard development organization. And these commitments, of course, compromise between patent hold up and hold out. So the risk of patentees using market power and leveraging injunctions to extract supra-front terms, but also protect the remuneration of stakeholders against unreasonable delay and tactics that delay front compensation. Further, let's say, component of this background is the industry practice of global SCP portfolio licensing. And so rational companies holding global portfolios, so portfolios of SCPs granted in multiple states, license those portfolios to companies with products that are sold globally on a global level. And this is, let's say, a rational practice. At the same, on top of this, we have and national courts have developed the practice of determining global front terms. And so, of course, UK courts have been leading this trend, but nonetheless, we have several other courts nowadays, both in China, but also in Europe, that have entered this field with their own global front determinations. And against this background, we move to the somehow novel. I mean, it's just about 2 years old, UK practice of the global interim license declarations. And in certain cases, we see an analogy between some of these declarations and the old Franzosi's concept of the Italian torpedo. So for those that do not, let's say, do not remember, but the concept of the Italian torpedo is quite established in patent law, at least European patent law circles, but it's the practice whereby an implementer, usually an implementer asks a slow court, usually an Italian court or a Belgian court. I mean, these were those infamously known for their slowliness. They ask those courts for a declaration of non-infringement and use the legal rule of lis pendens to delay parallel proceedings. And so essentially, because of the equivalence between an action for declaration of non-infringement and the mirror image of an infringement action, the later says court for infringement has to stay proceeding pending the Italian ones for declaration of non-infringement. And the torpedo, let's say here, functions through delay in the Italian case, while what we see in the UK jurisprudence is somehow a use of a torpedo that is actually not delaying, but actually preempting parallel proceedings. And here we have always implementers, so users of technologies, that request UK courts to grant a provisional global licensing declaration, and the effect de facto impairs parallel proceedings. And in general, this is somehow, we see that procedural strategies in SCP litigations, and so the way that the sequence of courts in which courts act can shape the substantive value, the outcome of front licensing negotiations, so affect willingness, injunction leverage, and settlement value. And here we see, like, moving from the right of the screen to the left of the screen, let's say that the procedural tactics, let's say, move from, let's say, the final and quite far in time final adjudication to, let's say, earlier on in the negotiation up to the current practice of global interim license declaration. Giacomo, I leave you here.
Thank you very much. So we hold that the English torpedo rests on two main points. And the first traces back to the Unwired Planet decision of the UK Supreme Court of 2020. Why we go back 6 years, that is a lot in SEP litigation, because the English judges recognize that Unwired Planet is the source of the principles I just quote here. Lord Justice Arnold in the Court of Appeal decision in Lenovo says a critic might argue that a degree of jurisdictional imperialism is already hardwired into Unwired Planet. Is talking about that decision. So Unwired Planet is problematic, especially in the conversant link, because it fits in the red danger zone that we have put in the diagram. So the UK Supreme Court allowed English global jurisdiction based on a very thin jurisdictional ground that was the existence of a UK patent. In that case, all parties were not English domiciled or headquartered in England. English law was not the law applicable to the dispute, and there was no choice of London as place of jurisdictional arbitration. So it's not the typical maritime insurance financial case that belongs to the courts of London. And we believe that this mismatch between the special, very specific ground of jurisdiction and the global scope of the relief is, let's say, the source of many of the evils we are talking about. And contrast this to the ideal zone, the existence of a consent by both parties for a court, could be an English court, could be another court, to settle their global dispute. This is the ideal ground upon which such a global reach of jurisdiction could be based. And equally acceptable, we think, is, and balanced, is the Court of Justice of the EU approach as announced in Luxembourg BSH, where the Court of Justice allowed EU member state court or the UPC to assert global jurisdiction, but only when the jurisdiction is based on the defendant's domicile. Defendant's domicile is called general jurisdiction, is the defendant's home, where in principle a plaintiff may bring any kind of claim against that party. Now, this is not to say that there are no exorbitant tendencies also within the EU. An example that I just want to mention, and we can talk a little bit more during the Q&A, is the use of an anchor defendant to bring foreign parties within the global jurisdiction, such as it was the case in the Philips Paris decision of 2020 or the Vestel Hague decision of 2022. But in principle, as witnessed by the UPC decision in Fujifilm Kodak that was just issued in June 2026, the approach in BSH, it seems a very balanced approach as opposed to the generous and exorbitant grant of jurisdiction that we saw in Unwired Planet, and that now is the basis of all interim license, or some of the interim license declaration cases. So back to you, Nicola.
Yeah, and so in particular, we analyzed the evolution of the case law, and here, let's say, we see an initial enlargement of the doctrine on UK interim global declarations, starting from the early Panasonic through Alcatel and Lenovo cases, while the second part, the second trilogy of cases, somehow traces back some limitation in its own UK Court of Appeal jurisprudence. Let's say the basis for the declaration, according to the UK judges, is the recognition that FRAND is not just an outcome, a benchmark of a final license, but also an ongoing process where there is also an obligation according to the applicable law, in this case is either French or Swiss law, to negotiate in good faith. And because of this French or Swiss good faith negotiation duty, then it is possible for the UK courts to grant interim declaratory relief and somehow hold the ring while the final FRAND determination is pending. And in this way, the effect is to prevent parallel litigation elsewhere between the parties pending the final UK determination. And here we move from the case in Panasonic, where actually, I mean, it's the SCP owner that sued and agreed to the UK final determination, and after that request actually started the litigation elsewhere, and then the reaction of UK judges somehow telling to the SCP owner, actually, no, you should stop, and in the meantime, you should also grant an interim license that has the effect of preventing duplicative parallel litigation. And then this was a case of ETSI standards. Then in Alcatel, we moved to other standards. So not really the same FRAND obligation, but a RAND obligation under ITU standards. And I mean, this case, it's a procedural case, so there is not a definite interpretation of the applicable RAND commitments, but nonetheless, the Court of Appeal allows the defendant, Amazon in this case, to amend its claim and also ask for not just an interim license declaration, but also a specific performance obligation to enforcement of that license. Note that in this case, Nokia, that was not a party originally to the case, but was the parent company of Alcatel, was brought into the litigation, but did not consent to the final global UK rate determination. Then perhaps we have the case that is perhaps most problematic in face of jurisdiction and jurisdictional issues, because in Lenovo we have the implementer that sues first the SCP holders and asks for an interim global license declaration. So here we don't have the SCP owner, let's say, consenting to the UK jurisdiction in the very first place, as opposed, for example, to the Panasonic and somehow also the Alcatel case. And after this first trilogy, then the Court of Appeal somehow traces the limitations of the acceptable interim license declarations. And so, for example, in Samsung, where there were reciprocal cross-licensing, interim cross-license offers, I mean, the defendant here, ZTE, actually preferred to have a final FRAND determination by a Chinese court and not by the UK court, and this was deemed not to be, let's say, a breach of the good faith negotiating duty. So in this sense, UK courts recognize that they are not the only courts that can determine final global FRAND terms. Then TP-Link is perhaps the most straightforward case, where both parties consensually and so mutually agreed to the interim license regime. So in this sense, there was no private international law friction, no comity risk. While the most recent case, Acer Asus versus Nokia, here we see, let's say, the apex of the evolution of the case law, whereby the Court of Appeal recognizes that an interim license offer subject to adjustment before a credible and neutral arbitral tribunal, such as the one of the ICC as proposed by Nokia, is actually compliant with the relevant, with the applicable FRAND licensing obligations. So we see, let's say, a movement that enlarges the doctrine at the beginning and then restrains it to cases of consent, mutual submission, or arbitration. Then, let's say, moving from the jurisdictional issues to the legal basis issues, we as the court also took a look at the applicable FRAND or RAND licensing commitments, and what we see is that the textual basis is lacking. So none of the relevant SDOs, IPR policies has a specific choice of law, choice of forum clause, which would allow, let's say, this type of declaration, so preventing wasteful litigation elsewhere, and also does not identify final or interim FRAND terms and conditions. So somehow we see this more as a construct of the UK court's interpretation rather than something grounded in the applicable licensing commitments. And also there is somehow of a difference between the license commitment to, let's say, a final license and this secondary implied right to a global interim FRAND license. Also, we see the good faith, the use of good faith by the UK courts somehow as bizarre. This is a concept that is alien to the UK law, and the UK judges use it because the applicable law is different. It's French or Swiss, but somehow, I mean, it's somehow it's something as a far stretch application of the good faith principle, which cannot simply supply a missing contractual or jurisdictional foundations. So somehow, let's say, we are skeptical of the legal basis as identified by the UK courts.
But how does this English torpedo works? Now, Niccolò, remember that the Italian torpedo relied on delay, but here the torpedo relies on speeds and precision. So we have foreign SCP actions pending, and then a party, now usually the implementer, applies to the English court, not for an order, but for a declaration of what the terms of a global interim license would be, and what a willing SEP holder would agree to. And then this non-consensual, so when also the SEP owner has not agreed or asked the English court to issue such a declaration, brings and catch the SEP holder into what we call the willingness trap. And the willingness trap is basically not a friendly advice, but resembles more an offer you cannot refuse. And in the, again, words of the Lord Justice Arnold in the Lenovo case that is so relevant for the reasons Nicola explained, Lord Justice Arnold says, faced with a decision by this court that Ericsson are in breach of their obligation of good faith and a formal declaration that a willing licensor would enter into an interim license, would Ericsson really persist in conduct that this court has unequivocally and publicly condemned? I not only hope that Ericsson will see the error of their ways, but consider that there is a real prospect of them doing so, end quote. And if we look at especially the UPC Mannheim decision in Interdigital, the choice of the word used by the court for saying that Panasonic, in the case, the earlier case of interim license declaration, eventually accepted the interim license, is Panasonic bought, now submitted, turned the head to the English interim license declaration. So regardless of the name, declaration, and of the formal element that this is not an order demanding the SEP holder to actually sign the license or enter into the license, the willingness trap is real, and it's something that, as I just mentioned, brings the party into a offer you cannot refuse situation. So the choice is between taking and actually agreeing to the interim license in the terms defined by the English court, and then ending injunctive proceedings everywhere in all other jurisdiction, or leave it. But leave it, as Arnold LJ just remember, is a dangerous game. It can open the party to finding of unwillingness by the English court or by other courts, can also be the basis for SDO complaints, but also it was mentioned in Alcatel, I believe it could be the basis for a request for specific performance. So we hold, and we try to explain in the paper, that interim license declaration are like an anti-suit injunction, could become like anti-suit injunction. The reaction now quickly, because our time is up and we want to leave time to Q&A, but the reaction by European courts especially in the Interdigital versus Amazon saga, has been a stark reaction. So the legal basis for European courts, German and UPC, to react is threefold. First, there is the consideration that patents are absolute rights, so a substantive basis, the right to exclude unlicensed implementer from use. Then the fundamental right of access to court to an effective remedy that is granted by EU law and the European Convention on Human Rights, and also the measure of EU competition law that colors all SEP negotiations. So basically, based on these grounds and considering the interim license declaration in England, a tortious interference with all these rights, the court have issued orders. Now, these are real orders subject to fine and penalties to discontinue or not propose the interim license declaration. So far, we have to say that these counter order have been defensive in the sense that they replied to, let's say, an interference from abroad, and they were tailored to just protect the jurisdiction of the court. But we cannot hide from the consideration that this escalation of jurisdictional conflict might bring also European court to overstep their boundaries. And in the paper, we try to identify let's say, other mechanism that could solve the issue without continuing through this path. So back to you, Nicola.
Yeah, so very quickly, I mean, we're moving to the conclusion, but so there is definitely some efficiency, like some paternalistic efficiencies in the interim license declarations. But I mean, this is not the only possible necessary solution to give interim access to the technology while litigation is pending. So actually, as already foreseen by the Court of Justice interpretation of the dominant SCP owners' good faith negotiation duties in Huawei versus ZTE, I mean, security should be the default option in those cases where the parties disagree on an interim license. And so security protects both against hold up, as demonstrates willingness on the side of the implementer, also protects against hold out because money at stake and will be recoverable in the end, respects party autonomy, so doesn't oblige parties into an interim license, does not authorize use, and so doesn't have that de facto effect, anti-suit injunction effect on foreign proceedings, and does not provide a benchmark, provisional license benchmark that can be used elsewhere due to the non-discrimination limb of FRAN, and most importantly, preserves foreign adjudication and remedies. Besides, I mean, security, I mean, what could be the possible, let's say, in an ideal world, the possible solutions to this tension, to this somehow also competition between courts? Of course, I mean, the STO's IPR policies are mostly silent on the issue of interim access to the underlying standardized technologies, and so somehow subject to the collective action problems, and so they need to find consensus. But there could be more in the IPR policies, such as even without a formal amendment of those policies, even just the endorsement of model clauses, model submission clauses, or reciprocal standstill obligations, or endorse neutral dispute resolution mechanism. This would be already something, and we acknowledge that some smaller SDOs have such kind of clauses, such as DVB, for example, regarding arbitration of disputes of FRAND access. Then we see positive developments at the international level at WIPO, and where the several SCP owners have pledged to submit to WIPO mediation for disputes with IoT SMEs. And so we see this as a very positive development. Of course, needs consent on the side of the IoT SME implementer. So here again, consent is key. The actual final point of the UK case law in Acer, it's definitely something that somehow restores a balance. So the interim license is offered and is subject to an adjustment before a forum where the SCP owner submits to be bound. And finally, also, we still need to see how the UPC Patent and Mediation Arbitration Center will play a role in these disputes. We acknowledge that its arbitration rules somehow have incorporated concept of and solution regarding interim access pending adjudication.
Okay, and to conclude, we don't think that all English interim license declaration are qualifiable as English torpedo when there is mutual consent. For sure, this is not the case. Possibly when English court have general jurisdiction because the defendant is at home in England, this could be also another exception, but it's more a middle ground. Surely a torpedo could arise when an implementer asks for a non-consensual global interim license declaration, and the only jurisdictional anchor is a UK patent, the existence of UK patent. European courts so far have shown a measure of restraint in the reaction that has been stark and bitter, and this reaction should continue to be measured and should be watched closely because the risk of exceeding the boundaries is there. And the criteria that we should use to evaluate and assess the conduct of all courses should be symmetrical. We shouldn't just take a pro-English or pro-European or pro-Chinese approach, but try to find a path that will reward and punish, in a sense, equally all jurisdiction, depending on the facts of the case, on whether the defendants are located in this or that jurisdiction, and based also on the claims and the strategy of the parties. Just to close with a practical remark, it seems that for the time being, SEP owner should think twice before applying for an injunction in the UK. They risk an interim license declaration, because by suing, you submit to jurisdiction, and they should not, when brought to England as defendant, waive their challenge to jurisdiction. They should not forget to appeal, because in 2 cases, Lenovo, Ericsson, and also Alcatel, Amazon with Nokia, the English court said, okay, you have not appealed the decision, so English jurisdiction now is established, it's proper. And finally, they should consider whether the UK patent is something of a liability, possibly, as it is an anchor to English jurisdiction, or whether it's still worth investment. Let's not forget that this is only part of the picture, but when we come to decisions on the merit, English courts are not necessarily pro-implementer, and the Optis Apple recent decision is an example of the SEP holder getting a large share of the cake. So these are complex litigations, and as we try to show, there shouldn't be a prejudice or preconceived position, but an analysis based on, I would say, the usual criteria of private international law: general jurisdiction, specific jurisdiction, comity, self-restraint, and so on and so forth. So thank you very much for your attention. And Axel, back to you.
Thank you so much. I mean, it helped me to understand many things. But if we start with a few questions that we have here, just to make sure that everybody really understands. So why describe the interim global license declaration as an English torpedo? And how does it differ from the traditional Italian torpedo?
Go, Nick.
I can go. So no, thank you, Axel. I mean, this is a key in our paper. So I mean, the expression of the military expression of a torpedo, let's say, describes a functional use, a strategic use of the procedure, of the litigation procedure, and we are not trying to somehow judge the judicial impropriety, let's say. I mean, this is something that just describes the procedural strategy. And I mean, the analogy with the Italian torpedo is one that sees, let's say, where we oppose, let's say, the delay of the Italian torpedo, so where the implementer, the infringer, obtain priority, so prioritize a slow-moving court, thanks to the least pendants rule, to obstruct proceedings elsewhere. I mean, instead here in the English torpedo, there is, let's say, the effect is reached through remedial acceleration. So always the implementer, the alleged infringer, somehow seeks a provisional global licensing relief, global declaration, before foreign courts have their own determination regarding infringement, validity, willingness, or remedies. So let's say this is why we use torpedo, and we oppose it to the Italian slow torpedoes with the UK fast torpedoes.
Okay, so that's a question of speed. Yeah. But when I was listening to you, I was wondering, just for the audience, the research paper is about to be published, like in the next few days. So I'm sure that you will be able to dig into this. But when is an interim license declaration legitimate, and when does it become an object show-nable English torpedo?
Yeah, thank you, Axel. we think that there is a degree of acceptability. So if there is a request by both parties or a submission by both parties to English jurisdiction, then the interim license declaration is a remedy that the English court have read into the French law or Swiss law, and this might be questionable under those laws, but in the international sense, this is an acceptable remedy. The interim license declaration becomes a torpedo precisely when the basis of jurisdiction of English court relies on a very thin piece, which is the UK patent. But all parties are foreign, are non-English, and French law, Swiss law applies, and there is no choice of court in favor of London, no submission. So in this case, we are in the danger red zone, and the interim license declaration will appear groundless. And the sole purpose for this interim license declaration could be seen as disengaging proceedings pending elsewhere. So the only function of those interim license declaration would appear to be preventing injunctive relief, say in Germany, in the United States, in China, and so on and so forth.
If I may jump in, Axel, I mean, to name and shame, let's say, also, if possible, to go back to the slide with the chronology of the cases. I mean, let's say that the torpedo concept would apply to surely to the Lenovo case, where it's the implementer that sues first, uses a UK patent, a UK SCP to anchor jurisdiction, but that UK patent is not even enforced by the SCP owner.
What is important, sorry, Niccolo, is that Nokia challenges English jurisdiction, but does not appeal the rejection of this challenge. And this is when the English court says, okay, now that you have not pursued your challenge to the end, I think that English court have global jurisdiction and there are no objection to that. I think this is key, at least from private international law perspective.
Ericsson, though, Giacomo. So
also not, if I recall correctly, yes.
What are the internal limits of Samsung versus ZTE, Acer versus Nokia, and TP-Link versus Huawei placed on the English interim license declarations?
Yes, so I mean, starting from Samsung, Axel, I mean, in Samsung there was, let's say, a different preference regarding which forum should be competent to set the final front terms, and so we had Samsung on one side that preferred the UK courts, and instead ZTE that preferred the Chongqing court in China, and that preference for another court was judged as not evidence of bad faith alone. I mean, as long as the foreign court is itself competent and neutral and capable of a final FRAND determination, that is, let's say, can comply with FRAND and can be a legitimate interim FRAND license offers. Then we move to, I mean, TP-Link versus Huawei. I mean, here, I mean, both parties agreed to enter into an interim global license. And so there is no risk for committee. It's not there is no private international law issue. And so, as we try to argue, I mean, consent is key, is king, and when parties consent can do much more than what the jurisdictional basis otherwise would allow. And finally, let's say the apex of the case law in Acer, Asus versus Nokia. I mean, here we have a interim license offer that is adjustable not before, let's say, not in the face of a final FRAND determination by the UK court or another court, but by an arbitration tribunal. And here the choice for arbitration, especially a neutral and objective and reputed arbitration such as the International Chamber of Commerce one, I mean, this is something that is FRAN compliant according to the UK court. So the interim license offer can be subject to adjustment, not before the UK court, but before another court, as in Samsung versus AT, or even arbitration, as in Acer versus Nokia.
And from many parts, you hear talking about arbitration as being the good alternatives to this jurisdictional fight all over the world. And I think we all agree that fighting in many jurisdictions is a waste of resources, it's expensive, it's the consequence of the system as it is built. So the idea that a SEP holder can include an arbitration agreement in the interim license declaration offer is really a step forward in a sense. So it could be the vehicle through which parties will finally agree to identify one place where to settle their global dispute.
That's very interesting because so we received several questions saying, and what are the reactions of the UK courts on orders such as the Samsung versus ZTE with the Zhongqing decision, or the orders coming from the Munich and the UPC Mannheim, in the case with Interdigital versus Amazon?
Yeah, well, we know that the Interdigital Amazon dispute now should have been settled, or almost, but let's say it's on the pathway to settlement. I recall at least one anti-suit injunction by the High Court, but it was very narrow tailored anti-suit injunction covering a few weeks, few months, just to allow the UK court to exercise its jurisdiction over the case, but very narrowly tailored, not to infringe on the UPC jurisdiction. So this is the reaction that I recall, Niccolo. So it was an anti-suit injunction nonetheless. So
anti-ante,
yes, anti-suit injunction. Yeah.
And what's the willingness trap created by court-endorsed interim license?
Yeah, no, I mean, this is let's say the key to the functional equivalence between the English torpedo, so the case where both parties do not consent to the UK jurisdiction, the SCP owner doesn't want to enter in a global interim global license. And so this is, let's say, the key effect, the useful actually effect in the words of the UK judges of the declaration itself, because the declaration itself, and probably should be stressed, does not create a global license. I mean, the effect of the declaration is not even, let's say, cannot be enforced. I mean, it's just a declaration that a willing licensor would grant an interim license of that type that the judges deems fit. And the effect is actually created by the factual result of the declaration, because the SCP owner faces the choice that Giacomo explained. So either entering into the identified interim license declaration, and in this way providing a contractual defense to infringement proceedings elsewhere, because the interim license, overall, it's a global one. And we also recognize that in case the UK declaration were limited to the national UK market, I mean, that would be somehow much more problematic, because it would have no de facto effect on parallel proceedings, but this is something that has not been the case. So the alternative to entering the interim license is to refuse it, but refuse it comes with quite important consequences for the SCP owner. So unwillingness, not just in UK courts, but possibly also elsewhere. So somehow also putting off the table injunctions, and possibly even consequences of breach of SDO's IPR policies, so at the level of a standardization organization. So the consequences are quite significant.
And let's not forget that the English approach in this field has been highly incremental. So first we have broad jurisdiction under Unwired Planet. Then we have a first case, Panasonic, where Panasonic didn't behave very well. So, okay, justifiable. Because at least Panasonic had applied to the UK court for injunction, so in no way submitted to jurisdiction. Then the same approach was brought one step further in Alcatel Amazon against Nokia, but at least Alcatel had acted in the UK. Nokia was joined as a necessary party. It's the anchor defendant and the anchor party, let's say, case. And then we have Lenovo versus Ericsson, where Ericsson was just a defendant, did not apply to the court, and so on and so forth. So not only this declaration work in practice, so parties actually agree to the terms identified by English court, because you don't disregard English court very lightly, but also you see an incremental approach, so nobody knows what the next step could be if one party would, in fact, to disregard such a declaration.
That's very interesting. You just talked about the SDOs, more or less, but do the EDC, ITUT, and IEEE instruments provide a sufficient contractual basis for an interim worldwide license?
No, I mean, thank you, Axel. I mean, this was we had to rush on this during the presentation, but I mean, looking at the textual wording of the different FRAND or RAND obligations, I mean, there is explicitly, let's say, the not even the grant of a license, but like the preparation in all of the three SDO's IPR policies or for IEEE in the letter of assurance, there is the preparation to grant even a license. So somehow it's one step even before an actual and final license. And so an interim license would bring it even like two steps before the preparation to grant a final front license. Also, the IPR policies, none of the IPR policies at issue specify in depth, specify what is FRAND or RAND. I mean, we have, it's true, we have under the IEEE licensing framework, under the license of assurance, that the agreement, let's say the concession that prohibitive orders should not be asked for by the SCP owner. I mean, but in that case, I mean, the need for an interim license declaration is even smaller, because let's say the injunction threat, the prohibitive order hold up effect is off the table. So even possibly in the IEEE framework, the interim license declaration are even less motivated than the other two, than ETSI and ITU-T. And let's remember, of course, that the case that involved the IEEE standards is TP-Link versus Huawei, where actually, I mean, the parties consensually enter into a global interim license. So there was no need for the UK court to engage deeply in the contractual interpretation of the IPR policy.
And as Niccolo mentioned during the presentation, let's not forget that the English judge is using French law, Swiss law, or other law to achieve a result that normally would not be achievable under English contract law. And this is very singular. And the way foreign law is applied in the UK, we know it's a question of fact, not a question of law. But we read an article by Nicolas Bictin and Jacques Devera that consider the application of French law denationalized. So it's applied not on French law terms, but on an external vision of French law. So nobody's really sure whether they got it right, just to put it with a joke.
But could competition law actually independently justify a court-imposed global interim license or not?
I mean, competition law, I mean, at least from the European perspective, has definitely a role to play. But the way that the Court of Justice has interpreted this is not through the lenses of a global interim license that puts injunctions off the table. So, I mean, it's important to remember that the Huawei ZTE framework, I mean, applies in cases of where Article 102 of the treaty, the prohibition of abuse of a dominant position conditions are present. And so, where first of all, an SCP owner is dominant, but I mean, even in those cases, does not per se exclude injunctions in SCP litigations. I mean, injunctions are permitted against unwilling licensees, and I mean, of course, in the negotiation steps of Huawei ZTE, I mean, there is the possibility of an offer and a counter offer by the implementer, but once the counter offer by the implementer is refused, the Court of Justice is explicit in asking for security. And as we try to explain, I mean, security is effective in balancing both hold up and hold out, while not having this extraterritorial imperialistic somehow effect of the declaration of the interim license that authorizes worldwide use and so diffuses parallel litigation elsewhere. So competition law, I mean, as could not justify, let's say, the interim global license declaration, is definitely in favor of a security mechanism.
Interesting. Because we are approaching the end of this webinar, I would like to ask you a question. Can you give us a hint on what practical framework does the paper propose for future multi-forum SCP disputes? In 2 minutes.
So I mean, to me, I mean, if in my short answer, it's consent. So and of course, I mean, it would be much more efficient to have a global dispute before an agreed forum. So whether it is an actual national tribunal or regional tribunal such as the UPC, or an arbitration, an arbitral tribunal. So let's say consent should to a single forum should be, let's say, my preferred route for solving multi-forum disputes.
And when consent is not there, which is not always the case, we propose to apply the season and old principle of private international law. So avoid exorbitant criteria of jurisdiction, such as just a patent, and try to fall back on general jurisdiction criteria of an accepted nature, which the most accepted is the domicile of the defendant, the forum rei, as it is called. So consent or accepted broad criteria of jurisdiction, otherwise territorial restraint. Just focus on your jurisdiction and don't look beyond the borders.
So thank you for this introduction to the conclusion of your paper. I'm sure that the listeners will definitely have to read your paper to fully understand what are your recommendations. To be very honest, I'm not a lawyer, and it helped me a lot to understand, this topic and how things are getting together. And it is complicated. So I hope that your recommendation will be followed by the different parties. So we could have discussed for a few more hours, I guess, and having the opportunity to dig into this topic. But now it is the time to conclude, and I would like to thank you very much, Giacomo and Nicolo, for sharing your knowledge, for taking the time to just share your expertise, right? That's a good time to announce that there will be the forthcoming paper. Again, I'm not exactly sure when that will be published, but that will be definitely in the next few days or 1 week maximum. Then I would like also to thank all the participants to this webinar. We really appreciate your questions, even though we have not been able to take all of them. And the recording will be made available, as I said earlier, tomorrow or in next few days on the 4IP Council website. You can subscribe to our newsletter by scanning this QR code. You won't be alone during the summer. If you are on the beach, you will be able to read the research papers, listen to the webinars, listen to the podcast. I'm sure all of you will really enjoy this. Finally, I would like to remind you that tomorrow you will be receiving an email just inviting you to complete a short 1 minute survey. If you have any topics you would like us to cover for IP to work on, please make your suggestions. Use this opportunity to get your voice heard, and we'll be very grateful for your feedback. Thank you again, Giacomo and Nicolo, for having your participation today. And I wish you a great summer break.
Thank you.
Thank you, Axel.